Thank you all for joining us today. My name is Carlie Bacon, and I am joined by my colleague, Erin Roycroft. Erin and I are both attorneys at Tonkon Torp here in Portland, Oregon. We both specialize in labor and employment law. We represent private and public employers regarding employment issues. And lately, Erin and I have been focusing our efforts on many COVID-19 related topics for employers, which brings us to our discussion for today. So welcome to our webinar. Well, it's OSHA Emergency Temporary Standard, very aptly named. Our goal today is to provide you with practical advice for your business. So to ensure that we have time for all of the important topics today, Erin and I plan to address questions at the end of the presentation. Please feel free to submit questions in the Q&A section of the Zoom app. Because this rule is so new and OSHA has not yet taken any sort of enforcement actions on it yet, we may not know the answer to your question. Also, your question may be too nuanced or specific for us to address in this webinar format. So if you have questions that are unique to your business, we invite you to reach out to us directly or the Tonkon Torp lawyers you typically work with to discuss your specific situation. Another note before we dive in, please know that we are actively recording this webinar. You don't need to sign a disclosure and no private information of yours will be shared. Please know, however, that should you choose to participate in the Q&A section, your question may be recorded in association with your name. You are welcome to submit questions anonymously if you prefer. Finally, any information presented here today is as of today, November 10th, 2021, and is not intended to be legal advice. Okay, so with that, let's go on to the meat of it. An introduction to OSHA's ETS. ETS stands for Emergency Temporary Standard. It's a rule, it's a standard, and it became effective on Friday, November 5th, 2021. OSHA has stated that it will be in effect for at least 6 months, but it could be extended longer depending on the state of the pandemic and whether it continues to pose a grave danger to employees in the United States. So 6 months at minimum. There are two key deadlines for employers to keep in mind. These are the two key compliance deadlines. December 6th, 2021, that's for nearly every requirement under the rule. The second deadline is January 4th, 2022, and that is for the testing option. If you're wondering what these requirements are in the testing option, we're going to dive into that next. So first of all, the ETS, which Erin and I will be referring to it as the ETS or the rule or the federal rule throughout the presentation. So if you hear us use one of those terms, that's what we're referring to. The rule does not apply to all employers. It applies only to employers with 100 or more employees across all of their workplaces in the United States. OSHA estimates that the rule will cover 2/3 of the United States' private sector workforce, which amounts to over 84 million employees. So as you can imagine, OSHA intended for the rule to have very broad coverage. So when determining the number of employees in your business, employers must include all of their employees in the US, as I said, and that is regardless of their vaccination status. So if they're vaccinated, unvaccinated, whatever the case may be, they count. And it also doesn't matter if they work at remote work locations or tiny work locations where it's maybe just 1 or 2 employees. If they are employed by the company, then they count. So some people who are included are listed here for you. Remote employees, they count. Employees who work away from the workplace. So think about traveling salespeople or maintenance workers who are sent to customer locations. Those people count as well. Part-time employees, union employees, temporary employees, seasonal employees, employees who work exclusively outdoors, and minors. all of these types of workers fall under the umbrella of, do you employ 100 or more people to be covered by the rule? Just to be clear, independent contractors do not count. And that's because by definition, they are not employees. So you don't have to count them. Next slide, please. And you might be wondering, why 100? And OSHA gave some guidance on what they were thinking when they implemented this rule. So the reason for 100 employees as the threshold is that OSHA anticipates that larger employers will be able to have the resources and the tools to immediately comply with this rule, whereas smaller employers might not be able to do that. They also wanted, as I said, broad coverage. So they wanted to reach a lot of private sector employees in the country. Third, they chose 100 because they hoped to reach large facilities where the most deadly COVID outbreaks can occur. And finally, OSHA stated that they chose 100 employees as the threshold because that's a similar threshold for other rulemaking contexts. So if you're wondering 100, that's why. So an important thing, and actually, sorry, Erin, I jumped the gun on the slide. Would you go back? Thank you. So the timing for when the employer has those 100 employees is important. If an employer has 100 employees or more on the effective date, which was November 5th, then the employer is covered. They're covered as of that date, and they're covered throughout the duration of the rule. So let's say, ABC company employed 200 people on November 5th, they're definitely covered. Well, if later they do a massive layoff and reduction in force, and now they only employ 80 employees, it doesn't matter. If the rule is still in effect, they are still considered covered. Likewise, if you have an employer who employs less than 100 employees as of November 5th, so they weren't covered at the outset, and maybe that's some of the people watching from their homes or office right now. If the company later employs 100 people at any time when the rule is in effect, then they are covered as of that date and again throughout the duration of the rule. So in other words, coverage is kind of a constantly evolving thing depending on the employer's workforce. So keep an eye on your employee numbers. All right, now we can go to the next slide. Okay, so here are some of the specific contexts that OSHA gave a little more guidance on. So first up, franchises. In a traditional relationship where the franchise location is independently owned and operated, the franchisor and the franchise would be considered separate entities. So the franchisor would only count their corporate employees, whereas the individual franchise location would count all of the employees that they employ there at the location. So, if we had a burger joint, the corporate employees for the burger joint would count as one entity, and then all of the employees working at the local burger place, the franchise, would count separately. And then staffing agencies. When employees of a staffing agency are placed at a host employer location, only the staffing agency would count these jointly employed workers for purposes of the 100 employee count. The host employer, however, would still be covered by the rule if it has 100 or more employees in addition to the employers of the staffing agency, or the employees of the staffing agency. For multi-employer work sites, the most common example I think of is like a construction work site where you maybe have a general contractor and then subcontractors beneath. Each company represented would need to count its own employees. So the host employer and general contractor would not need to count the total number of workers at each site, but rather their own individual employees. Again, the count is not based on individual locations, it's based on the employer's entire workforce. So each employer must count the total number of workers it employs, regardless of where they report for work on a particular day. So for example, if a general contractor has more than 100 employees spread out over multiple construction sites, that employer is still covered by the rule, even if it doesn't have all 100 of them gathered at one site at one time. And then these last two, federal contractors and subcontractors and Medicare, Medicaid, healthcare employers are not covered by this particular ETS that we are discussing today. And that is because they are covered by their own separate rules, which OSHA has deemed are, adequate to protect the safety interests that OSHA wants to protect. And so they're not going to try to bring those employees under this specific rules umbrella. So federal contractors and subcontractors are covered under the Safer Federal Workforce Task Force COVID-19 Workplace Safety Guidance for federal contractors and subcontractors. It's a mouthful. I didn't come up with the title, obviously. So we will not be talking about those employers or employees covered under that rule today. Likewise, we're not going to be talking about this last bullet point, the Medicare, Medicaid, healthcare employers, because they are also covered under a separate rule, the Centers for Medicare and Medicaid Services Omnibus Healthcare Staff Vaccination Interim Final Rule. If you are concerned about whether or not your business might be one of those two categories, then please reach out to one of us, and we'd be happy to provide some guidance there. Okay, so let's move along to covered employees. The rule does not apply to employees, certain types of employees of covered employers. So even if you are one of the businesses that has 100 or more and you're covered by the rule, that doesn't necessarily mean that as an employer, you have to enforce the rule against all of your workers. It depends. So some of the employees who are not covered are those who do not report to a workplace where other individuals, such as coworkers or customers, are present. Another example is employees who work from home, so long as they consistently work from home. If you have a remote employee who intermittently comes into the office or goes to a workplace where customers might be present or coworkers might be present, then they are covered during that time that they are present. And third and finally, employees who work exclusively outdoors. This one has some specific points for what it means to work exclusively outdoors. So the employee must work outdoors on all days. If they work indoors at any point, then it's not exclusively indoors. Also, the employee may not routinely occupy vehicles with other employees as part of their work duties. So for instance, if you've got yard maintenance workers who work outdoor all day, every day, but they go to the job site with a coworker in a work truck, then that's also not exclusively outdoors because those two coworkers are in the same space. Also, a point to the outdoor space is that even if it's outdoors, if there are walls or roofs or other barriers that make it so it's not truly outdoors, then that also does not meet this exception. Okay, so this lower bullet point, Oregon and local government employees will be covered. So, and that is because Oregon is one of the 26 states and United States territories that has its own state plan. And because of that, it's an OSHA approved state plan. Because they have that in place, state and local government employees, such as educators and school staff, are covered by this ETS. And this is just part of a requirement of the OSHA Act. So even though federal OSHA does not have coverage over those employees in states without OSHA approved state plans, here in Oregon, we do have that. And then The rule does not apply to employees who work for federal agencies. And that is because those types of employees are covered by an executive order that OSHA considers compliant. So they don't fall under this either. Other than the United States Postal Service, because that is considered a private employer. Okay, let's move on. Okay, so now that we've gone through who has to comply with the rule and when that has been determined, which employees have to be covered under that enforcement, what do employers actually have to do? Well, implement a policy. And there are two options for employers to choose from. First, they can have a vaccination mandate for all of their employees. So just an across the board mandatory vaccination rule. Of course, a rule like that is still subject to accommodation requests from employees for disability or religious reasons. So if you have an employee coming to you and stating that they have a medical condition that precludes them from becoming vaccinated, then that must be treated as a request for accommodation based on disability. On the other hand, if you have an employee who says that they have a religious belief or practice or observance that conflicts with and keeps them from getting vaccinated, then that should be treated as a request for religious accommodation. Erin's going to be talking a little bit more about those later on, so I'm not going to dwell on it. So there's option one. Option two is a more lenient approach in the sense that employers can allow employees to choose. They can either choose to become fully vaccinated, or if they do not want to become fully vaccinated, then the employee must submit to regular COVID testing and wear face coverings. So sort of a two-pronged approach. It is okay for employers to have a partial mandatory vaccination policy. So that's in regards to number one. That kind of situation is okay when employers have portions of their workforce who they want to have fully vaccinated, and then other portions where maybe it's less important. So for example, let's say we have a large corporation where some employees are working at the company's headquarters while others are able to work from home and others are working at the company's like actual stores or sites helping customers. So when you have that type of scenario where there are different types of employees, the employer can choose whether they want to require vaccination for some of the employees, such as the ones who are in the stores providing day-to-day services for customers, or to treat vaccination as optional, such as for the employees who are working intermittently from home. This still complies with the standard so long as the employer makes sure that they're fully following the vaccination principle and the testing and wearing face coverings for those it's optional for. Okay, so I think we can go on to the next slide, please, Erin. Thank you. What does it mean for an employee to be fully vaccinated? There is a much more long, convoluted definition in the rule, but brass tacks, it's 2 weeks after the person has received the final dose. If it's the single dose, Johnson & Johnson vaccine, then 2 weeks after they get that one shot, they're fully vaccinated. If they have the 2-shot vaccine, 2 weeks after they've received their final dose. And that also, this definition also requires that the appropriate waiting times in between shots 1 and 2 has also passed. So that's what it means to be fully vaccinated. Also, it must be an approved vaccine. So maybe some people have heard in the news about Aaron Rodgers saying that he was immunized, but turns out he was not actually vaccinated. You can't do that. You have to actually get an approved vaccine, and the rule defines what that is. So it's one that is either approved or authorized for emergency use by the FDA. It's listed for emergency use by the World Health Organization, or it's a vaccine that is in part of a US, a clinical trial in the US. So long as the employee gets the actual vaccine, they don't get a placebo. And this has some other little technical requirements. If you have an employee who's going to go the clinical trial route, then check in on some of the details because there's a little bit more there. Okay, next slide, please. So what does regular testing mean? In a lot of news articles, they just say weekly testing. That's not entirely accurate. It is weekly testing for employees who are coming into the workplace regularly. It's less often for employees who don't come in consistently. So for instance, if you have those remote employees who are working from home but coming into the office from time to time, then regular testing for them means that they need to get a COVID test 7 days prior to when they will enter the office. So it takes a little more planning. Okay, so regular testing is required for all employees who are not vaccinated by January 4th, whatever the reason is for them not being vaccinated. If that's because of a request for accommodation that's been approved, if they just don't want to and the employer's policy allows for that. If you have an employee who's not vaccinated by January 4th, they need to submit to the regular testing. A note on that from OSHA is that employees who have completed the entire primary vaccination by January 4th do not have to roll into this testing requirement, even if they haven't actually completed the 2-week waiting period. So a little extra wiggle room from OSHA there. We already talked about what regular means. It depends on the employee's attendance. So as of right now, the federal rule does not require employers to pay for any costs associated with testing. Rather, that can fall to the employee. The rule also doesn't prohibit employers from paying for testing costs. So if your business would prefer to cover that for employees, you're welcome to do so, but it's not required by the federal rule. For Oregon employers, the issue is not entirely settled how it's going to play out here in Oregon. We are waiting to see what Oregon OSHA has to say about that. They will be releasing their own state plan, and we absolutely anticipate that Oregon OSHA will address this testing costs question. So stay tuned. And then an important note is that if an employee does not provide the results of their regular COVID testing to the employer, then the employer has to keep them out of the workplace. That's basically like their golden ticket to get in. And if they don't actually hand over the test results, they can't come to the workplace. And they must be excluded from the workplace until they provide a test result. Okay, next slide, please. Okay, so what actually counts as a test? It needs to be a COVID-19 test that has been cleared, approved, or authorized. There's the full definition there at bullet 1. I won't read the whole thing. It has to be administered in accordance with the authorized instructions, and not both self-administered and self-read unless observed by the employer or an authorized telehealth proctor. So, it's got to be a bona fide COVID test in a nutshell. Antibody tests do not meet this definition. So that's something important to keep in mind. Okay, next slide, please. Face coverings. What is a face covering? I know in common parlance, most people say face masks, myself included. However, the rule does treat the language differently. In the rules context, a face mask is more like a medical mask that, like doctors, nurses, healthcare providers wear, whereas a face covering is what is required by the rule. A face covering must completely cover the nose and the mouth of the employee, and those plastic face shields, they do not count. And that is because the face covering has to be 2 layers of fabric, closely woven, and it needs to be, tied on and close to the face can't have slits, can't have holes. So just, the typical cloth face masks that we're probably all very used to seeing do comply. Again, face shields do not. Okay, next slide, please. All right, so again, unvaccinated employees, and again, for whatever reason they're unvaccinated, whether it's a request for an accommodation or an allowance under the employer's policy, unvaccinated employees must wear face coverings in the workplace, other than a few minor exceptions. So if an employee is alone in a room with floor to ceilings, windows, and a closed door, such as my lovely office here, they don't have to wear a face covering at all. However, if I were to get up and go outside of my office and be wandering around the hallway getting a cup of coffee, then I would need to wear my face covering during that time. Also, for eating and drinking, and this can't be the kind of thing where people are like nursing a Diet Coke for 3 hours so that they don't have to wear their face covering. OSHA is not going to let that fly. It needs to be a reasonable amount of time just to eat and drink and then put the face covering back on. The third and final instance where it's okay to not be wearing the face covering is for identification purposes in compliance with safety and security requirements. So if there's a safety check where the person needs to quickly reveal their face, that's fine. The rule does not require face coverings for fully vaccinated employees. So that's nice. However, that is not the state of affairs here in Oregon. As a reminder, here in Oregon, as of August, face coverings are required indoors statewide, and they're also required in most outdoor public settings as well. So if your workplace falls into one of those two categories, then face coverings are definitely still required here in Oregon. Okay, next, please. All right, paid time off. So no matter which policy the employer chooses, whether it's a vaccine mandate across the board or the optional vaccine, the employer must provide up to 4 hours of paid time for each primary vaccination series dose that the employee gets. That includes any travel time that they spend going to and from. And it also includes any other sort of reasonable time that goes towards getting the vaccine. So if they're, registering to get it, if they're filling out their paperwork beforehand, anything like that, that kind of falls into that same paid time off umbrella. However, employers do not have to reimburse employees for any sort of transportation costs. If that were the case, I'm sure employees would be off to like San Diego to get their vaccines, and it's like an all expenses paid trip. That is not the case. You don't have to reimburse them for anything. It's just the paid time. And that's, again, just to help remove the burdens of that OSHA assumes have blocked employees from getting vaccinated thus far. Also, this paid time under this rule cannot be offset by any other leave that the employee has accrued, such as sick leave or vacation leave. OSHA doesn't want that kind of disincentive as part of this. So it's additional paid time on top of that. Another key note is that this only applies if the employee is seeking their vaccination during work hours. So if they're doing it, if they work Monday through Friday, but then they're going to go get vaccinated on Saturday after brunch, you don't have to provide the paid time off to them for that. Another note is that if an employer chooses to have like a vaccine clinic at the work site, again, that time that the employee is using to get vaccinated, even if it's at the employer's workplace, that still needs to be paid time. The other form of paid time is a reasonable amount of paid sick leave to recover from any side effects. And again, that's also during scheduled work hours. So that can occur after each dose. Employers can require the employee to use their paid sick leave that they have available for the recovery, not for getting the vaccine, but yes, for the recovery. And if they don't have any available, then, of course, it just needs to be provided on top of that. OSHA has said, because of course, what does reasonable mean? OSHA has provided guidance that employers can, generally speaking, cap the amount of recovery time at 2 days after. Employers don't have to anticipate that they have some employee who's going to get horribly sick and have side effects for like 2 weeks. 2 days is generally reasonable, according to OSHA. Okay, next slide, please. Employee notification of positive test and removal. So the OSHA rule requires employers to boot infected employees out of the workplace. So as part of the policy, employers must require all of their employees to promptly notify them of a positive COVID-19 test or a diagnosis from a healthcare provider. And then upon receiving any such notification, employers need to immediately remove the employee from the workplace. They can continue working from home. That's fine. It's not that they have to be unemployed during that period, the removal period, but they can't be around coworkers and they can't be around customers. They need to be away from the workplace. Unlike the paid time that is required to get the vaccination and to have recovery time, employers do not have to provide paid time off during the removal period under the OSHA rule. But remember, if you're an Oregon employer, there are other laws in place, such as Oregon sick time law. And so be sure to check your policies and your coverage under state laws that may require employers to pay paid time off if you have someone infected with COVID. Under the OSHA rule, though, it's not required. Then when it comes time for the employee to return to work, they can't just waltz back in. They have to comply with one of these 3 lower bullet points. They have to provide a negative COVID-19 test. They have to satisfy the isolation guidance from the CDC. We do not have time to get into that, but it's widely available. Or they can provide a recommendation from a licensed healthcare provider showing that they are approved to return to work. Okay. So during this time, if you have an employee who does test positive for COVID-19, for 90 days thereafter, they don't have to submit to the regular testing requirement. It's just for that 90 days. And then when the 90 days is up, unless they're vaccinated at that point, then yes, they do need to, again, submit to the regular testing. Of course, the 90 days is not the removal period. They can return to work sooner as long as they meet that criteria. And when they do come back, they must continue to wear a face covering if they are unvaccinated. Oh, here again, no paid time off required under this rule, and check Oregon law. Okay. Next slide, please. I think that might be it for me.
I think this is me.
It is. Okay, take it away, Erin. Thank you, everyone.
Right. I feel like Carlie just talked about the meat and potatoes really of this rule, and I'm going to dive into a little bit more of the nitty-gritty requirements for things like records keeping, notice requirements. We'll talk about accommodations, and then if there's time at the end, we'll talk a little bit about the legal challenges, which is a little fun topic for me, but I'll save it to the end. So one of the other requirements, in addition to everything that Carlie just mentioned of the rule, is that you have to provide certain information to your employees. This is one of the requirements that must be met by December 6th. It's under subsection J of the rule. This information has to be provided to the employees in a language and literacy level that the employee understands. And there's basically 4 key pieces of information that you have to provide notice to your employees of. The first one is the requirements of the rule. And included in that is any policy that you create. The second thing is this document from the CDC, key things to know about COVID-19 vaccines. You can probably Google it and find a link to it, but there's a hyperlink there. The third thing is related to any anti-retaliation and anti-discrimination provisions of the OSH Act. I'm not going to cite you the statutes, but they are in the rule. And the fourth thing, and I feel like we should dub this the Erin Rogers rule, Carlie. You have to inform your employees that there are criminal penalties for knowingly supplying false statements or documentation under certain provisions of the OSH Act. Employers have flexibility regarding the method of providing this notice. So you could send all this information to your workforce through an email. It could be through printed fact sheets. You could submit the information orally during a discussion, like a team meeting. And those are just some examples. So there's a lot of flexibility there, but those are the 4 key pieces. There's also record keeping requirements, and quite a few of them. So the first thing I want to touch on are basically the 3 types of records that you either have to collect or create under the rule. Again, this is another December 6th deadline to be met. The first thing is the written policy. So Carlie discussed what types of policies you can choose. We'll get into describing a little bit later each element required of the written policy, but just know you have to create a written policy. You have to give it to your employees. There's no need to give it to OSHA. You don't have to submit it unless it's requested by OSHA, and then we'll discuss that in a bit as well. The second category of documents that have to be collected are vaccination records, and that is a digital or physical copy of any enumerated type of acceptable documentation from each employee. And then the third type of document that you have to create is a roster. So you have to create and maintain a roster of your vaccinated and unvaccinated employees. And I will touch on the written policy and then get into the vaccination records in a bit. So in terms of your written policy, there are 7 things that OSHA requires to be included in the policy. There are a number of things that are also recommended to be included, but the 7 things that you see on the screen here are what is required. So number 1, what are you requiring? Are you requiring mandatory vaccination, or are you allowing testing? That has to be in your policy, testing and masking as an alternative. Number 2 are the applicable exclusions from the written policy. We will talk about the contraindications and medical necessity requiring delay, as well as reasonable accommodations a little bit later. But those should be in your written policy. And I would also add, this isn't part of the OSHA rule, but I would also add as best practice to include a procedure for notifying your employees how to request those accommodations. Should they reach out to HR? Is there a specific form you should use? I would recommend that be included in your policy as well. The third thing would be information on determining vaccination status and how this information would be collected. 4th, paid time and sick leave for vaccination purposes, which Carlie's already talked about. 5th is notification of positive COVID-19 test and removal of positive employees from the workplace. 6th, information to be provided to the employees. So that was what I was just talking about. So for instance, how are you going to make that information available to your employees? And 7th, and probably most important, is what disciplinary action will you be taking for employees who don't abide by the policy? In addition to those 7 requirements, it's recommended that you include other relevant information. So the policy's effective date, who the policy applies to, the deadlines for submitting vaccination information or for getting vaccinated, and procedures for compliance and enforcement. The guidelines that we've been talking about regarding the OSHA's rule for the effective date or who the policy applies to, those are the floor. So you can make a policy that is effective sooner, or that has tighter deadlines, or that applies to more people than what the law requires. So that's just an option. And then procedures for compliance and enforcement as well. So I want to talk a little bit about what counts as a vaccination record, because I anticipate that these questions about what can I submit? I've lost my vaccine card. What can I submit instead might come up. And basically any immunization record from your healthcare provider is acceptable, or the pharmacy where you got vaccinated. The CDC vaccine card obviously will work. Medical records documenting vaccination. I'm not entirely clear what that means. It seems as though pretty much any official documentation from a medical provider, a state public health agency, or any other official documentation would work. Like I said, I anticipate probably more than one of you will have a question from an employee about what do I do if I've lost my vaccine card? The first thing that your employee should do if they've lost a vaccine card is to contact their healthcare provider and to try to get a replacement, or their vaccine provider. The second thing that they could do is to contact the state health department's immunization system. Some states, I believe New York and possibly California, have developed or are in the process of developing web-based apps where you can access your vaccine information from your phone when you need to show your vaccine card. I have heard that OSHA or OHA, the Oregon Health Authority, is working on a web-based app, but it's not clear where they are in the process of developing that or when it would be released. So in the interim, if employees need to contact the state health department for getting a replacement card, they can call 211 and they'll be redirected to the Oregon Health Authority's immunization department. It's called Alert. And they keep records, they keep and maintain records of immunization and should be able to provide a satisfactory vaccination record. If for some reason none of those options work, it is possible for the employee to provide an attestation. This should really be used as a last resort. The attestation should be in writing because obviously it's a record that you have to maintain. And it has to include all of the parts that you see here on the screen, including at the end, you will see the Erin Rogers statement that you understand that knowingly providing false information may subject you to criminal penalties under the OSHA Act. So in addition to collecting and creating the documents that we've just described, there are also record keeping and record retention requirements, as you probably could have imagined. So in terms of what records you're required to retain and where to keep them, you would want to treat the vaccine records that I described and the employee roster. Both of those are confidential medical records, so they should not be stored in a personnel file where supervisors and managers have access to those records. Instead, they should be stored in the confidential medical file. And unlike other OSHA-related medical records that are subject to a 30-year retention policy, these records only need to be retained for as long as this rule is in effect. Obviously, we don't know how long that's going to be, at minimum 6 months, like Carlie mentioned. But hopefully it's not 30 years. Another requirement under the rule, under subsection L is that employers have a duty to provide records to employees upon request. And there's basically two types of records, or two pieces of information that employers have to provide. When an employee requests, you have to provide the employee's own vaccination documentation and or test results to the employee or to an authorized individual. And you also have to provide information regarding the aggregate number of fully vaccinated employees and the total number of employees at that workplace. And it's worth noting here that you're only providing the numbers, you're not providing names or any other identifying information of other employees. Like, you wouldn't hand over your roster to an employee who asks it. Only the bare numbers of the aggregate numbers of vaccinated and total numbers. The time for complying with the request is actually pretty short. So the rule requires that by the end of the next business day following a request. So an employee makes a request on Monday for these records. By the end of the day on Tuesday, you have to provide that information, which is pretty short. There are also certain types of records and information that have to be disclosed to OSHA upon request. So the records that we're talking about are the policy, the roster. Those are for you to keep and maintain. You don't have to submit them to OSHA until OSHA makes a request for those records. In which case, again, there's some pretty tight timelines for producing those records. So within 4 hours of a request for from OSHA, you have a duty to provide the written policy and the aggregate number of fully vaccinated and total number of employees. And then at the end of the next business day, all other records required to be maintained. You also have a duty, I forget which subsection, and unfortunately I didn't mark it, but you have a duty to report to OSHA any COVID-related or work-related COVID-19 fatalities and hospitalizations. OSHA's created a fact sheet for how to identify a work-related hospitalization or fatality, and it's not specified under the rule other than you determine what is work-related as you would any other work-related OSHA injury or disease. So within 24 hours of the employer learning of a hospitalization, or within 8 hours of the employer learning of a fatality, the employer has to report those to OSHA. There's three ways to report, although I think safe to say if you find yourself in this situation, you might want to consult legal counsel about what to do next. So there are certain exclusions. Carlie touched on this earlier. There's certain exclusions from the requirements of the rule, certain categories of employees who are excluded. If the employer chooses a mandatory vaccination policy as opposed to a vaccination or testing and masking policy. Employees who have a medical contraindication for vaccination and those who have a medical necessity that requires a delay in vaccination are exempt specifically from that mandatory vaccination policy. In addition, no matter what policy you adopt, employees who are entitled to a reasonable accommodation under the relevant civil rights law would also obviously be entitled to an accommodation. OSHA's estimated that around 5% of employees will fall into one of these three categories of exclusions. When you're talking about or considering whether an employee has a medical contraindication or a medical necessity requiring delay, the relevant authority that you want to look to is the CDC, probably unsurprisingly. They've identified a few contraindications to vaccination. Primarily, it involves employees who have a severe or an immediate allergic reaction to some component of the COVID-19 vaccine. And this, in addition, the CDC also recommends delaying vaccination for certain groups of people. It's actually quite a long list, and I'm not going to describe them all here. Some examples are people who currently are infected with COVID-19, people who have a history of multi-system inflammation or inflammatory syndrome, or those who've received monoclonal antibodies or convalescent plasma treatment for COVID-19. That's a non-exhaustive list. So again, if you have questions about that, I would consult CDC and or feel free to reach out to legal counsel about that. In addition to the 2 medical related exclusions and the accommodations, as Carlie mentioned, federal contractors and Medicare and Medicaid certified employers are subject to their own requirements. The Centers for Medicare and Medicaid Services rule came out the same day as the OSHA rule. And it, may be the subject of a future article or webinar, but kind of beyond the scope of what we're going to talk about today. And the federal contractor and subcontractors, they're subject to Executive Order 1404, also exempt under this rule. And that deadline, I just want to note that deadline was moved back on the same day that this rule was released, was moved back to January 4th. So just to briefly talk about accommodations, because I know that, it's probably top of mind and it's almost guaranteed to come up. We could spend an entire webinar talking just about accommodations. So I'm going to be very, very brief. There's 2 types of accommodations requests that you could get. One is for disability, the other is for religious belief. For disability accommodations, if you get an accommodations request would be generated by the employee. If that happens, you've got a duty to engage in what's called the interactive process. Interactive process is a term of art that basically means have a conversation with your employee to find out what their medical needs are and how you might be able to accommodate them. It's entirely within your right to ask for medical verification. And if it's determined that the employee does have a disability, they would be entitled to an accommodation, not necessarily their preferred accommodation, but an accommodation, unless providing that accommodation would present an undue hardship or would present a direct threat to either the employee or other employees or individuals in your workspace. I guess anecdotally, I would say we haven't seen a ton of questions about disability related accommodations, likely because it's very straightforward. I think employees either have medical verification or they don't. The majority of questions that I have seen for accommodations are for religious accommodation. And this arises under Title VII of the 1964 Civil Rights Act, but also under relevant state and local laws as well. Employees are entitled to an accommodation if they have a sincerely held religious belief, practice, or observance that conflicts with your policy. If an employee asserts that they need an accommodation for religious purposes, you may seek additional information. You can ask, if it's unclear in which way does their religious belief conflict with the policy. If you have an objective basis for doubting either the sincerity of their belief or the religious nature of their belief, you are within your rights to seek additional information. The EEOC has issued some really helpful guidance on these points about specifically related to COVID-19 vaccines. Factors that could undermine the employee's assertion that they sincerely hold a religious belief that's in conflict with a vaccine could be if the employee has behaved in a way that is markedly inconsistent with the professed belief, If the accommodation sought is particularly desirable benefit, likely to be sought for secular reasons, whether the timing of the request renders it suspect. For instance, did they just request an accommodation for secular reasons and now suddenly they need a request, they're requesting an accommodation for the same benefit for religious reasons, and other similar types of red flags. Again, assuming that the employee has a sincerely held religious belief, they're entitled to an accommodation, not their preferred accommodation, unless it presents an undue hardship. And the burden for undue hardship for religious accommodations is somewhat low. It's lower certainly than for disability accommodations. It just means that the accommodation would have more than a de minimis effect on burden on the employer. So I'm going to zip right through. We could talk, like I said, we could talk about the accommodations forever. As Carlie mentioned, Oregon OSHA is going to issue a rule. Oregon's one of the states that has its own OSHA plan. Washington and California do as well. They've got 30 days to complete their own rules. That the requirements that we've been discussing today are guaranteed to be part of that rule. The rule that OSHA issues could be more protective of employees, but it's not going to be less. And it's too early to tell, according to OSHA, it's too early to tell what the timeline will be in Oregon. So I guess just stay tuned. Very briefly on enforcement, it's possible that OSHA could issue fines. In a press call that was released by the White House, an unnamed state official said that fines are possible with willful violations, seeing fines up to $136,000 per violation. Again, that's for willful violations. So I guess just be aware that fines are possible when it comes to enforcement. And just very briefly, I'll mention there was a lawsuit that was filed. Lawsuits are filed in many circuit courts by many different groups of plaintiffs. There was a temporary stay issued in the Fifth Circuit. The cases are going to be consolidated into a single circuit and decided hopefully soon. It's possible we could see these decisions heading to the U.S. Supreme Court. It's anyone's guess at this point what will happen, but OSHA has advised employers to not delay complying with the rules until these cases have been decided. So zipped through the end of that there. And I see we are not leaving very much time for questions. Carlie, have you been keeping an eye on the Q&A? Is there like one question you can pull out?
I can blast through. Also, like you don't have to stay past 5, everybody, but if you want to, we'll tap out a couple more. Okay, so someone asked, does the rule also apply to remote employees who do not visit headquarters or customers and suppliers? If they are truly remote, like 100%, they're always at home, then no, you don't have to enforce any of this stuff against them. They do still count towards the 100 though. Someone else asked, what if you are both? So if you have more than 100 or more employees and you're a federal contractor, which rule takes precedent? Erin, correct me if I'm wrong, but I think if they're a federal contractor, they should follow those requirements and not be,
they're specifically exempt from this OSHA rule. There's just different requirements for federal contractors. For instance, again, could be subject of its own webinar, but federal contractors do not have a testing and masking alternative option. So they need to follow their own rule.
Yeah. This is my favorite question. Is there a snowball's chance in hell that the injunction against the federal ETS becomes permanent?
Who knows? Yeah, it's certainly possible. Like I mentioned, there's litigation in multiple circuit courts right now. I think what we can expect to happen is that litigation will all be aggregated under the multi-district litigation, and it'll be randomly assigned to one circuit court to decide all of the cases. It's possible we could see the temporary injunction the temporary restraining order turn into a permanent injunction. Like I said, it's also possible that we see this heading to the Supreme Court. I note that 3 times now the Supreme Court has declined to overturn vaccination requirements in various settings. None of them involved federal agencies. So, you know, I don't know how much we can take from that, but it's certainly possible.
Awesome. Okay. If an employee requests an accommodation, can you require them to be weekly tested and produce a negative test? So if an employee requests an accommodation and assuming it's approved, and I assume that means that an accommodation to becoming vaccinated. So yes, once you're out of that land where they don't have to get vaccinated because of their accommodation, yes, you can still require them and need to still require them to wear face coverings at all times in the workplace and submit to regular testing, unless they again request further accommodations to one of those things. And then you're kind of you're doing it again, you know, going through the same accommodation process.
Yep.
Okay, cool. Are vaccinated personnel required to get the booster shot to be compliant down the road? As of right now, the rule does not require the booster shot. It's just the standard vaccination status. That could change though. I mean, OSHA says that they're going to continue to revise this as things progress. So could change. Right now, no, not required. Okay. Some of these are specific to business circumstances for people. And so those ones we're not going to necessarily address during the webinar. Let's see. How about, oh, we already addressed that. Okay, sorry. I'm going through all your Q&As on the app. Erin, are you able to see them?
Yeah, I was just looking through. It's just looking through.
Oh, here's one I think I can handle right off the bat. The question is, how can we make the current at-home tests work? If they test at work in front of another employee, will that check all the boxes? First off, it definitely depends on which home test you're talking about. It needs to meet OSHA's specific requirements. And there's a lot more that, you know, we didn't put on these slides. So I would recommend, you know, going and checking out the rules exact language on that point to make sure that the test meets those requirements. Assuming it does, step 2, OSHA says that the test cannot be self-proctored, so the employee can't just read their own test and be like, I'm good. The employer needs to do it. I don't, Erin, you know, jump in here too. I wouldn't recommend having another employee do it unless they are like a member of human resources.
Yeah, I would probably agree with that. It seems like that all kinds of problems could arise there.
Yeah, because, you know, the results of their tests and the fact that they're doing it also, I mean, even the fact that they're submitting to regular testing is all arguably confidential. We don't want to get into that messy land. So if you have HR, go through HR, or likewise, like on-site medical staff, you know, like some employers have nurses, that kind of thing.
I see a question that I think we can answer pretty quickly from Robert saying, we have 165 field employees spread out at 34 client sites around the company. Are we covered? I think the answer is it depends, but probably. The test is really who the employer is, not what location do they work for. So if you have employees, if you have over 100 employees that work at multiple different locations, you still count each of those locations. You combine each of those locations when you're counting your employees.
Yep.
Yeah.
Actually, I'm not sure about that. This might be a good, well, do you want to, there's a religious accommodation question at the bottom. If a religious accommodation is stating belief doesn't allow vaccination or testing, can you accommodate and be in compliance?
Yeah, I haven't seen, I think honestly, religious accommodation to testing is a new one for me. I haven't seen that yet. So it would depend a lot on the particulars of the request. But I think, yeah, there's definitely room for accommodating testing and face coverings within the rule and still being in compliance.
Yeah, I think the face coverings there would be very important. And, you know, again, if you have employees who maybe can work remotely, that's another option to consider, so that you don't even have to worry about it.
Yeah, I think it really depends on what kind of accommodation you can provide that is safe and keeps your other employees safe, keeps that employee safe.
Okay.
You want to pick one more? So I feel like we're running into.
Sure. Great questions, everybody. Okay. Let's see.
If we give the option to test weekly and wear, sorry, this is from Barrett. If we give the option to test weekly and wear a face covering because we have 100+ employees, do employees still have an option to request an accommodation from regular testing? Yeah, I think we just answered that one. The answer is yes.
They can certainly request it.
Yeah, you don't have to give it. You would engage in the process that I talked about earlier in determining whether there is a sincerely held religious belief that conflicts with the policy and whether that can be accommodated without an undue hardship. But I think the answer is yes.
This one's a good one. For positive employees to return to work, we gave 3 options for them to return to work. Can our requirements be more strict, such as requiring a doctor note and a test? Generally, yes. The 3 requirements that were listed on the slide that we went over, those are, it's one or the other. Like if the employee meets one of those, they can return to work. But if you as an employer want to have requirements that go above and beyond OSHA's minimum requirements, as long as they don't conflict, as long as you're not running afoul of OSHA's requirements or other laws, generally speaking, yes, you can do that.
Here's a good one. I almost, I feel like you're going to kick me for picking this question, Carlie, because it's one that OSHA has not been very clear on. But how do they measure employee counts? Is it through payroll reports? I feel like OSHA has been intentionally a little bit vague about that. So I think, probably my inclination would be to who are your W-2 employees? Like, what do you think, Carlie?
That's tough. I mean, exactly. OSHA, I haven't seen anything from OSHA about how they intend to investigate that. But generally speaking, when OSHA seeks to enforce its rules, they might do just a random site inspection of your work site. So, I mean, they could even just do something as rudimentary as a head count or a roll call, if it's like a huge employer, right? They could also do a request for information and have you provide documentation that they want to try to figure it out. They have their crafty ways. Payroll reports are definitely, I think, one of them. Yeah.
Okay.
Well, there are a few more. Should we?
Go for it.
Well, I don't want to ignore anybody. Is rapid antigen test appropriate for the purpose of testing?
I actually don't know this off the top of my head because there are a lot of FAQs through OSHA, and I have not memorized all of that. But what I would suggest is to either reach out to an attorney to answer that specific question or to look on OSHA's FAQ section for the ETS. I think
it looks like they can meet the definition of a test.
Yeah. Okay, great.
Yeah. So yeah, like Erin was suggesting, verify that. But yes, generally speaking, antigen tests can meet the definition of a COVID test. What are the requirements of vaccination and testing for on-site temporary workers provided by employment agencies?
So if I recall, Carlie, I think those temporary workers are considered employees of the employment agency, not of the host employer. And so they would be subject to the agency's policy. However, I think there was some guidance that the host employer can require them also to follow their own testing and vaccination policies as well.
Mm-hmm.
So I think it's sort of a both, like a yes and answer.
I think that's right. And like, certainly, for instance, if an employer were to learn that one of those temp workers, like, for instance, tested positive for COVID, like, they would still need to like get them out of there, you know, and exclude them from their work site. Like, there's still the OSHA has a general duty clause, or rather the OSHA Act does. So all employers are just required to provide a safe workspace for all workers and employees there. So I think that would also just fall under that.
Mm-hmm.
Beyond that, I'd have to go back and look at kind of the particulars of it. One more question. Let's just do it. Maybe like nobody's even on the webinar anymore. That's okay.
I kind of want to take this one because I think the answer, I mean, tell me if you disagree. So the question is, if the employee has previously shown the vaccination card to the employer, is there leniency shown to the employer for relying only on the roster? So can they rely on, it sounds like, can they rely on their memory of having seen the digital card or the card previously rather than requiring it? And I don't think that that is recommended under the rule. I do think you have a duty to maintain vaccination cards for each employee. So you need some vaccination record. It doesn't have to be a card, like I mentioned. It could be medical documentation from a provider or from the state health authority, or it could be the vaccination card. It could be any other official documentation. It could be, as a last resort, the employee's own attestation that they lost their vaccination documentation, but that they have been fully vaccinated. So I think for each employee, you do need to maintain a vaccination record, even if it's not the actual card. You can't just rely on your memory of having seen those cards before the rule took effect.
We did it.
We did it. All right. That's the end, everybody. Thank you so much for hanging in there. Thanks for going a little bit over time. And
we still have 31 people. You guys just can't get enough.
I know, it's amazing. There's a lot of questions. This rule is a beast. It's really confusing. If you have questions about implementing this at your specific worksite, please reach out to us or whoever your typical labor and employment attorney is at Tonkon. We'd be happy to help.
Thank you all. Have a great night.
Bye.